we're going to be looking at land ownership in Nigeria. You agree with me that there are a lot of disputes as regards land, and how do we resolve them one after the other forms the crux, basis, and pivot of this special episode. And I'm also being joined by the managing partner of Noah Attorneys. That's the law firm Noah Attorney that's based in Benin City, Nigeria. And he is Dan Osa Ogbege. Good to have you join me, Dan Osa Ogbege.
Thanks for having me this afternoon.
All right. Well, good to know, because for quite some time now we've missed an opportunity to have you and discuss these issues one after the other. But good to know that you're here.
I've been quite busy with a lot of activities coming up, around this period.
Okay.
I have to squeeze out this time to be here today.
Yeah, most especially when it has to do with land ownership. You agree that there's been a lot of disputes. It's either communal disputes or issues that has to do with encroaching with the land of the government. And
exactly.
all of this need to be, discussed and bring about solutions to the problems that seem to bedevil, the society in this direction. But let's look at the nitty-gritty about land. I know basically the land is not just subsisting of the space and the soil.
Yes.
It's more than that. So can you give us a concept of what land is all about?
It's a lot more than that. It has to be stated that, land does not just mean the soil or the subsoil. It goes beyond that. It includes everything that is on the land, whether trees, whether cultivation, anything that is cultivated on the land, even before now, even the mineral resources beneath the surface of the land, and this definition of land is most appropriately represented by the Latin maxim, quique platator, solo sedate, which means that whatever is affixed to the soil belongs to the soil.
Okay.
And, before now, there were definitions by the courts that land even includes everything that is on the land, going down below, then also reaching up to the sky above. But there have been legislation, to restrict that broad definition of land.
Okay.
Now, for instance, mineral resources that are under the soil belong to the federal government of Nigeria. For instance, in Nigeria, belong to the federal government. Though in some countries, especially the Middle Eastern countries, or even in the U.S., the mineral resources on your land belong to you.
Okay.
But in Nigeria, it's not exactly like that. So you cannot exactly say that you own everything on the land reaching up to even the sky, because the airspace in Nigeria belongs to the federal government of Nigeria. So it is not to the individual owner of the land or the community owner of the land, no. It belongs to government.
Okay.
So there are legislation to restrict the prior broad-based definition of land in Nigeria.
Okay, well, let's look at land ownership. I know it cuts across that owned by the government or the community or the family or individuals.
Yes.
So can you just make a reel out of
this?
We
have, there is communal ownership of land.
Yeah.
There is also individual ownership of land. The communal ownership of land comes before the individual ownership of land. It is assumed that land belongs to the community, that now, grants parts of the land to individual members of the community. At times, first to the family, then to the individual. So it comes from community, family, and to the individual.
Okay.
Then since 1978, the promulgation of the Land Use Decree, that is now the Land Use Act, land in the state belongs to the governor of the state.
Okay.
Yes.
Before we delve into that aspect,
okay,
there's been issues about issues of litigations as regards communal land and how it's been located to individuals. For instance, a situation where a first buyer, of the land, seems to have a delay in the development of such property. We've seen where, those in the community will have to resell, and then after much talk about it, they now have to relocate or transfer another land to the first owner. At what point can we say this is legal?
Well, ordinarily, An owner of land is an owner of land in perpetuity. There's no restriction or limitation as to the duration of time that he needs to develop the place before he can. After that, he may not be able to assert ownership. That ought to be illegal.
So that's an arbitrary act.
Yes, but the principle of law that parties are bound by the agreement between them will not suffice. Where a community gives you land allocation approval and under the right that you must develop within 5 years.
Oh.
You know, some people say you must develop within 3 years.
So if there's such an agreement.
So if you agree to it, then you'll be bound by it.
You know, a lot of people
So
just read it.
You cannot,
a lot of people just
they don't even
peruse
look
this
at it.
document
And most times,
without knowing what is essential.
yeah, a lot of Nigerians, they don't even peruse document. Most times they just sign it and go. And especially when you are desperate to get something, to buy something, you are desperate, you just want it. You are not going to look at you won't look at the whole agreement. You won't look at some of the conditions or some of the terms in the agreement. You just sign. And many Nigerians, they don't have personal lawyers. And they don't show the agreement, whether tenancy agreement, land, transaction agreement. They don't even look at it. They just sign away because they know, oh, this is my place. So after 3 or 5 years, as the case may be, the community goes in and take it. Then you start complaining. Oh. And they are going to show you, bring the document. You bring the document, they show you the place. And many of these people, even if they are illiterate, but they have the wisdom, they have the street sense to be able to excuse themselves from liability.
Okay, lesson number one learned here is that you must peruse every document.
You must peruse every document.
Before you make append your signature.
You must read every line. And I will advise any buyer, anybody that is going into a transaction, show the document to a lawyer to peruse it for you.
Okay, let's look at the other aspect. Still on this matter.
Yes.
Is it resolute? Is it definite that if one appends his signature to that agreement, he or she cannot appeal for the law court to, do justice to it? Because some of them may say they did the appending of the signature out of ignorance.
No, the ignorance
or
of the
is
law
ignorance is no excuse?
Yeah, ignorance of the law is not an excuse. If you sign, unless you say it was by duress, and you have to, prove it. You have to show evidence of that duress. If not, you are bound by that agreement.
Okay, I think that's what you call ignoramus non excusat.
Exactly.
Okay, let's look at the community land, for instance. Does a community hold ownership of a land for a long time? And at what point can the government decide to revoke if it has the powers to do that?
All lands in urban area belongs to the governor of the state.
Oh, urban.
All lands in rural areas belongs to the local government council. But in practice, communities exercise ownership of land. They exercise acts of ownership of land in their domain. That even most times, a governor cannot just move into a community and say, I'm taking over this land. Cannot. They have to, the governor have to appeal to the heads of the community, to the principal members of the community, to say, oh, we need this land for so, and so. For instance, a few days ago, the governor of Edo State, Gordon Obaseki, went to commission the barrack, the barrack he built for the Nigerian Army at Iho in Hunde Local Government Council. And he announced in that place that because of the insecurity on the Bini Auchi Road, he felt that the state would need army points, soldier points in that vicinity. So he approached the Nigerian Army. They approved the setting up of that particular army point. I don't know what they call it. I can't quite remember it. And he also went to the Enogi of Iho and appealed that he needed a place at Iho to put that kind of structure. And the Enogi gave them that piece of land. It's a massive piece of land. And the governor built the military barrack, their offices and everything. So, since the military have been there, we've not had the security issues in that environment.
Okay.
from Benin to maybe Auchi, Aziz. We've not had that. So he was the one that approached the Enoge, and they gave him that land. So in practice, the land still vests in the community, because most communities are rural communities anyway.
Okay.
Yes.
Thank you. Well, in case you're just watching, it's Law and You, and we're looking at land ownership in Nigeria, and I'm with the managing partner of Noah Attorneys, a firm based in Benin City, Nigeria, and of course, we're looking at the real cost or crux that has to do with ownership of land in Nigeria. And my name is Philip Omo Gyupo. Don't forget, we're going to be reading out numbers on the screen, and you can reach us via the numbers on the screen. You can also use that to articulate issues that you have as regards the topic, and justice will be done in that regard, because you own Law and You, and basically you get justice for that. Now, Dan Osagbege, let's look deeper, let's delve deeper into the aspect, because you may mention of the ownership of the urban areas that is under the state government. Now, let's look at what it means for us to say statutory rights of occupancy. What does the Act explain?
No, it just means that you apply to the state government to give consent to your transaction in a land. Now, for instance, you bought a land. That land is transferred to you. Or a land that has, you now apply to the state government to get documentation.
Okay.
That you're actually the owner of that land. It is called, they call it certificate of occupancy.
Okay, certificate of occupancy.
Yes,
that's another word for it.
Yes.
Okay.
But having certificate of occupancy is not even a conclusion. It's just one of the proofs of ownership of land. There are 5 proofs of ownership of land in Nigeria. These 5 proofs were stated in the case of Idudun and Okumagba, where the Supreme Court gave 5 different ways whereby titles to land could be established. So that right of occupancy or certificate of occupancy is just an aspect of it.
Oh.
You also show that you have been in possession of that land for a very long time.
And that cannot be done without even showing a document to show the land survey. But I
Of
think
course,
that comes first, even before
whether
you
the
get
survey, the survey
the
plan,
certificate of occupancy.
certificate of occupancy, all of these things you are able to show.
If you are
At
able to
times,
show all
I
this,
advise,
are they not enough already to show that?
that is the point. If you have a better title, now the court has to satisfy itself that you have shown a better title. Now somebody has, for instance, a deed of transfer. Another person has a certificate of occupancy.
That shows more
And
originality.
that certificate of occupancy is able to show the history of the transaction of that land, to show that the person genuinely bought from a successive line of those who have exercised acts of ownership on that land. Now, somebody comes and he brandishes a certificate of occupancy. But I have been on that land for, say, maybe 30 years. My father used it to farm. My father died, I inherited it. And I was farming on it, and I built on it. And you just come from nowhere and say you have a certificate of occupancy.
Without a history.
How do you have that certificate of occupancy? I might not even have any document, but I'm able to show that I've been in possession of that land for varied time.
That's under customary rights of occupancy.
Exactly. Even
because
yes,
when you said you may not be able to show
even
evidence,
if I don't have
in terms of document, that seems to be a lapse.
Hold on. I could misplace my document, for instance.
Why should you?
I could misplace my document.
Is that excuse?
But I have been on the land. What I'm trying to show to you is that possession is 90% of the ownership, of the law on ownership of land.
Okay, so if you can prove,
if I show
you can prove
that I
possession.
have been in possession for a long time, and my family, my father, my grandfather, have history of being in possession of that particular land, then you don't have to show that how did you get your document on the land. If I have been on the land for that number of years, for that number of time, because people could also fraudulently secure a certificate of occupancy. So having a certificate of occupancy is not a conclusive proof that you are the owner of the land.
That's a big one.
Many times people have, fraudulently acquired it without being in possession. And I could be illiterate, but I've been in possession. I've been there for a long time. My family owned it, and they gave it to my grandfather. My grandfather gave it to my father. My father gave it to me. And I'm showing this long line of history. And if I could also show that I'm the owner of the adjoining lands, I own the adjoining lands, the lands around that particular land you are talking about, then it will go to show that I actually own that land as well. Because if I could own, I should prove that I own the lands around that particular land. That means that I own it. So that's why I'm saying that having the document is not even enough. Sometimes some clients will meet me, I need to see your phone, that line, I need to see your phone. I will explain to them, if you don't have the money to, apply, go through all those.
To procure the document?
Yes, don't even bother. Okay, if you want, just do a survey on it. Because nowadays, those state government, they register the survey and put it in their system.
Okay, so there's a data for it.
Yeah, there's a data. So once they enter it, it will show that Philip Omogbon is the owner of that particular piece of land. So what is then the use of going to apply for a certificate of occupancy?
Okay.
Those are the things. So CFO is not a magical document that will not cure all defects around our land.
Okay, I know basically that there will be questions pouring in. Don't forget, the numbers are on the screen, and just for you to know and quickly react to all of this as we tie along. And I'm still with the managing partner of Noah Attorneys, a firm of legal practitioner based in Benin City, Nigeria. Thank you for still holding on.
Thank you very much.
Now, let's look at what you said concerning the certificate of occupancy and other documents to show. Some have always also reacted to the aspect where at a point in time, the government can also revoke licenses of these documents. I don't seem to understand that, because does the government have the right over the land that has already been given out and that already has a C of O?
I didn't know
if it has, at what point can it exercise that right?
I didn't know you were going to ask this question, because it ought to have been a topic it's a broad topic.
It's a broad topic, yeah, but we can just scratch this topic.
Exactly. It's a broad topic on its own. And for listeners, for viewers to also understand that this broad topic on ownership of land is going to be a series. We are going to take it maybe like 4 times so that we're able to exhaust all the subjects.
Yeah, and articulate them properly.
Yeah, exactly. But as regards revocation of land by a state governor, of course the state governor has the right to revoke land, but it has to be for overriding public interest.
For overriding
public
even when such a property has a C of O.
Yeah, even if, of course.
So
they can revoke it and they pay the appropriate compensation to the owner. But it has to be for the governor, because the drafters of the Constitution also looked at it, that it may also be, or the drafter of the Land Use Act, which has been incorporated into the Constitution, they also look at it, there may also be that the person that will be governor may maybe just be a mischief maker, may want to victimize his political opponent.
Exactly.
So they now made it that if you are going to revoke a land, then it has to be done by following the process. There's a process laid down, and we will talk about it much later. There's a process laid down for revocation of a land under the Land Use Act, and it has to be for overriding public interest, overriding public purpose, and it must not be pecuniary. It should either be for education or for health, or to create a pathway so that to solve erosion issues. For instance, areas where you have erosions in Benin, so the state government can just say, okay, we want to resettle you people, but we need to draw a path so that we can curb erosion in this area. So it has to be for overriding public interest or public purpose. And that interest, it must not be to give it to another person.
Thank
You
you very
cannot
much.
take from Peter and give it to Paul.
Thank you very much, Barrister Daniel Salgbeg.
Yes,
Quite
thank you.
awesome to have you join us. And I just hope that we're going to be having more time to have you on set with us
Also myself.
to discuss further on this subject, because it's quite an interesting subject.
Yes.
And I believe that basically the viewers will want to react to all of this that you just said. Well, this is much we can take on Law and You. We do well to show you, the extended part of this discussion. Same time next week. I am Philip Omogupo. Goodbye.